I'm a board member of the New York Planning Federation, which is why I was asked to speak. I'm also a principal, as it says on the notes, of Buckhurst Fish and Jacmar. And because nobody can spell that, we usually go by BFJ Planning, which is hence the stationery. Our firm, based in Manhattan, actually works here in the Mid-Hudson quite extensively, and also in Connecticut and New Jersey. And those laws are totally, New Jersey on zoning boards of appeals is way different. So it's, I'm just going to speak to the state law and the organization of this. And what I'd like to do is, rather than just my speak, as we go through each of these 8 points or so, as you have questions or disagreements, by the way, I was saying to two of the members of the Kent ZBA here that sometimes some of my ZBA clients in Westchester sometimes tend to be a little more, some of their procedures are just slightly nuanced differently than some boards upstate. So where you see some differences, raise your hand, and we'll have a discussion of that particular issue. But anyway, I wanted to go start with powers and duties of the ZBA, and I should start, before I do that, I presume most of you, how many of you are ZBA members? Okay, almost all of you, yeah, are ZBA members. So you know the powers and duties, but I always start with this. I mean, the basic function, and I think every state in the union has enabling legislation for zoning boards of appeals, because back in, after planning was, I should say zoning was upheld by the Supreme Court, the Department of Commerce, I believe it was under Herbert Hoover, published this model enabling legislation for the United States, and it has in it that you should have a zoning board of appeals. So I believe almost every municipality in New York, or everyone we practice in, has a ZBA, because someone has to be there to both interpret the zoning ordinance and to give relief from the zoning ordinance, because no ordinance is perfect. And you need a board to be able to grant relief from the ordinance. So every community I've practiced in here in the state has a ZBA, as opposed to some boards don't have, some towns do not have planning boards. But every town I'm familiar with, every village, has a ZBA. You really have to have a ZBA. And that's the purpose of it. It's necessary to provide relief from the strict interpretation of the zoning code, and that's the basic purpose of a ZBA. I'll get to special permits later, but I did want to mention here the difference between jurisdictions. The appellate jurisdiction of the ZBA. That's the jurisdiction that the legislature has given you and the courts have upheld. And by appellate, I mean you are taking an appeal. The Zoning Board of Appeals is taking that appeal of the determination, usually by the building inspector. Could be a zoning enforcement officer, but it's usually a building inspector. And you're taking that appeal and hearing it. And that's your appellate power. Now, some towns, the town board or the village board or the city council has given a ZBA what's called original jurisdiction, namely the ability to grant special permits. And I'll be honest with you, when we as a firm write new zoning codes, we don't give special permits normally to the Zoning Board of Appeals anymore. We give them to the planning board, because we find that there's a confusion many times. And I have a difficult time myself, new board members explaining, hey, you're here basically to interpret the code and grant relief from it. A special permit has nothing to do with that. A special permit is a totally different jurisdiction given to you. It's not an appellate jurisdiction. It's really an original one. Your town board has decided that a special permit should go to the ZBA. And the reason this happened, I believe, and I don't want to dwell on this very long, is that many upstate communities here in New York, they don't have planning boards. There's many upstate communities without planning boards. So when special permits were developed and came along, there was no one to give it to. And under our laws here in New York State, a special permit can be reserved by the elected officials to themselves. So your town board can reserve special permits to themselves. They can grant them to the planning board, or they can grant them to the ZBA. And I think what happens historically is the town board said, wait a minute, we don't want this. So let's give it to, and they didn't have a planning board. They only had a ZBA, so they gave it to the ZBA. But what we find in modern practice now is that a lot of special permits have to do with particularly planning issues or design issues. For instance, a lot of schools and churches are special permits, daycare facilities. It has to do a lot with parking, access, and how these things fit in to a site plan or a subdivision. And so if you give it to the ZBA, and by the way, I'm not saying they shouldn't, but if you give it to the ZBA, it means that that applicant is bouncing between the planning board, who has a certain idea, and you guys in the ZBA, which may have its own ideas on the special permit. So the ZBA may grant a special permit and condition it, and then it goes back to the planning board for site plan. Planning board doesn't agree with it. The applicant's caught in the middle. And so we've tended now in our new zoning codes to just send most special permits to the planning board. I just wanted to mention it because there's, in this handout, which was originally written by Jim Kuhn, it's called the Jim Kuhn series, he goes into the jurisdiction you have. ZBAs and only ZBAs have the appellate jurisdiction. You are the only board that can interpret the zoning code and grant variances. However, a special permit is not an appellate jurisdiction. It's an original one. The town board has to give it to you locally. It has to give it to you, or the village trustees. So there's a slight difference. I don't mean to dwell on that very much, but, and then as you know, I presume all your terms are either 3 or 5 years.
7.
You got a 7? Because, yeah, most of them are 5 in the state. And you've got a 7-year term. Okay, good. So, and then you're usually a 5-member board. Are some of you different? You just went to 5. You got 7. You can have 5 or 7, yeah. So that's the terms. And I just want to cover very briefly 2 things you'll see in the handout, and I don't want to dwell on them, but what the attorneys are calling incompatible. In terms of your board membership, they're discussing 2 things, usually incompatibility or conflict of interest. And the 2 are related sometimes, but if you're granting, you can't hear me? I'm going to move. Is this okay? If you're granting appellate relief from your building inspector, well, it's incompatible for the building inspector to be a member of the Zoning Board of Appeals. And it's got that's self-evident, I think, to everybody. So there's certain incompatible. Your town attorney should not be a member of the Zoning Board of Appeals. You know, so there's certain people that should not be. They're incompatible with that. There's others that may just have a conflict of interest. If you, the obvious conflict is an applicant comes before you and they're related to you, or you have a financial interest in their enterprise. That's a conflict, so you'd have to just recluse yourself from that matter. But incompatibility means you shouldn't be on the board at all. Conflict of interest is just you should recluse yourself from that matter. And I think what I find with our boards, I always tell people, in many of our villages and towns, we'll have an ethics board, so if a member has a question, they can just ask the ethics board. If they don't, I usually tell them, look, if you have a question or you're in doubt about it, divulge it. The safest thing is divulge it, so that you just say once, look, here's what my conflict of interest might be. I've referred it to the town attorney. He said this. So I'm either reclusing myself or I'm not. And you've divulged it, then you can't be accused of anything. So I think it's worth it to be on the safe side of, you know, the conflict of interest situation. We have that as a firm. In Dobbs Ferry in Westchester County, we had Stop and Shop before us. And we're their planning consultants, and we had once worked for Stop and Shop. So when the mayor was talking to me about it, I said, you know, Mayor, the first thing I want to tell you is in the village of Pleasantville in Westchester, we actually represented Stop and Shop. And the mayor's response was a surprising one. He said, that's great. I want somebody who knows the intricacies of a supermarket so that they can't fool the ZBA on something, you know, on the size they need and so on. So he said, I'll run that through our village attorney, which he did, and through the ethics board. A year later, Stop and Shop was in for an approval at the planning board, but they needed a variance. And we were at the Zoning Board of Appeals, and a citizen got up who was very, you know, smart, doing their homework. They had gone on our website at BFJ Planning, and they went through all our projects and found, aha, they worked for Stop and Shop. These guys shouldn't be doing this. They have a conflict of interest. To which the chair of the ZBA said, oh no, that was all cleared last year by our council. And the mayor's view was, we want BFJ because they understand Stop and Shops. They understand whether there's really an economic hardship in this case or not. So we had divulged it, thank goodness, because otherwise you have, you know, there's nothing worse to me than getting a conflict of interest charge made against you. So our experience with that has been always to, if you have a question, just divulge it to your village or town attorney or your ethics committee. So anyway, that's the first item I sort of wanted to cover here. Any questions, comments on that? Just going through item one. At any rate, number two, I think a lot of, I get fewer of these at the ZBAs in Westchester. I used to get them from a couple of, here in Dutchess County. I never forgot one in East Fishkill where we weren't sure where the zoning line was. And again, it was an interpretation of the zoning map that was sent. We sent that to the Zoning Board of Appeals to interpret the code. In this case, it was the interpretation of where an actual zoning line was. You are actually the only ones, the Zoning Board of Appeals member, who can make an interpretation of the zoning code. You're supposed to be doing that on a request, on an appeal. But for instance, the town attorney, and I know the village attorneys, are there any village attorneys here? Because obviously you would rely on them, you might rely on them, and they will give you their opinion. But they themselves are not the one to interpret the code. You are. You are empowered by state law to interpret the code. So you may rely on their advice, which hopefully is good advice, but it is only you who can, you know, make that determination. The zoning board is the only one in New York State, and actually all the states we practice in, which is primarily Connecticut, New Jersey, and New York, that can grant a variance. Now, I will tell you that we sometimes write new zoning codes so that we give some discretion, like on parking, to the planning board. We're very careful not to call it a variance. Sometimes we'll give a little discretion to the planning board, which is a waiver, right? We'll say, if you have an applicant before you, and that applicant is going to do some shared parking. It's a mixed-use building, some retail, this doesn't happen much, but some residential. None of the parking is going to be reserved. You know, it's not going to be Dr. So-and-so. It's not going to be by name. So it's all shared parking. In that case, we'll give the planning board, we write in the ability of the planning board to waive up to 10% or 50%, based on a study that they're given that. You know, so that's a little different. It's not a variance, but it has to be built into your code. The planning board cannot do something like that unless they're granted the authority by the town board. The planning board is not given the power to grant variances in New York State. Our view as a planning firm, we recommend to our clients that, to us, the planning board does not have a legal application before it if that application needs a variance. And therefore, the variance route is the route that should be taken first. In other words, if this application needs a variance, it should be sent first to the Zoning Board of Appeals and not to the planning board. However, I don't think this is a settled area of law. I have many attorneys saying to me, Frank, they ought to be able to go to the planning board, and to this part I agree, and get some preliminary feedback from the planning board before they go to the ZBA. I agree with that. But I don't like our planning boards. We advise our planning boards, don't give a final approval. Don't give a site plan approval or a subdivision if this needs a variance until the ZBA acts. Because you're acting on an application that the building inspector says should not be before the planning board. It's illegal. Until you grant the variance, it's not illegal. In my mind, it's not a complete or legal application. I know there's a, by the way, it's not a settled area of law. At any rate, on item 2, in interpretations, only you, though, not your building inspector, not your town attorney or your village attorney, only you, the ZBA, may interpret the zoning code. Now, by interpret, I mean the building inspector comes to you with a question, or an applicant's been denied something on the interpretation of the building inspector and appeals to you. Your job is to interpret the code. What obviously you can't do, and you know, in Kuhn's write-up, they go over this. You don't have original jurisdiction. You only have appellate jurisdiction. You have to weigh what's before you on the facts before you. You can't say, hey, gee, I think the zoning code, now that we're interpreting it this way, I think it should be clearer. Let's amend it. You don't have that power. Only the trustees of the village or the town board, the elected official, only the elected official may change the zoning code. You may not change it. You may only interpret it. So, but you are the only ones who may interpret it. So that's your interpretation power. As I said recently here, we had I rarely see this. ZBA was asked to interpret where is the zoning line. We weren't really sure. This was in the town of East Fishkill in a farming area, and we weren't really sure. They interpreted where the zoning line was for that specific case. So when you make an interpretation, it's supposed to be based on the specific case and what's been brought before you, usually by the building inspector. I'm doing a use variance first just because, again, Jim decided to do use variances in his publication first. But as you know, the ZBAs are granted the ability to look at use variances and area variances. And that's why I just bring with me wherever I go my little card, you know, which gives you the criteria on one side for a use variance and the criteria on the other side for an area variance. But the big thing that you all know is to say that the use variance, the reason I listed the rezoning question, the use variance is the much more significant variance to grant because you as a ZBA are saying, at least in this particular case, the basic underlying zoning of this site is wrong. And if you say that enough, you ought to communicate that to the town board or your village board, because they ought to consider, gee, if there's a set of variances, use variances, it begins to question the validity of zoning in a particular area. And it's why I think the courts have made use variances the more difficult variance to get. I mean, they've set it up, as you can see here, so that this is not, the use variance is not what I hear a lot, is that an area variance is a balancing act for the ZBA between you know, general detriment to the community and benefit to the applicant. It's just a balancing act, and you have sort of wider discretion on it. But the use variance, you really have to show hardship. You have to show uniqueness. And these are out of a court case. What happened was there were some court cases on use variances, and then the legislature, in amending the variance procedures, incorporated those court cases. So you can see the first one is whether the benefit can be achieved by other means feasible to the applicant. And the first one, of the use variance, you cannot realize a reasonable return. That's not an area variance. It's the use variance that says you cannot realize a reasonable return. So you can get into the finances of a particular application on a use variance. I don't see that on area variances. It's on a use variance that you can actually get into that. And as you say, it says, you know, substantial as shown by competent financial evidence. So you have the right to ask for that financial evidence. You have the right to ask for a financial pro forma. We're brought in many times. We have an economic group in our firm. We're brought in sometimes to say, I had one ZBA chair say, Frank, I want you to run through this financial pro forma. Are these guys right on this? You know, or have they sort of been somewhat generous on certain numbers? The Stop and Shop case I mentioned to you. We ran through some financials on it for the Zoning Board of Appeals. So you have the right to look at that. It's one of the few times you do. Technically in seeker, even though there's some professional planners here also, and even though we sometimes stretch seeker to ask for financial information per se is not a seeker issue. The only place I see it as really an issue is the use variance. You have a right to the financial pro forma. You have a right to see it. So, and then the second one, the hardship. The hardship is unique, and it doesn't apply neighborhood, you know, wise. It's unique to this site. I find, again, that's a tough requirement to meet, you know, for the use variance. First, you got to have an economic hardship, and it's got to be, or you have to find that it is unique to that particular site. And the third one is also an area variance, but the third one under use has always been there, that you're not harming. The variance will not alter the essential, you know, character of the neighborhood, and that gets repeated a little bit in the area variance. Now the fourth one is the most difficult one to me, and I've never been able to answer this 100% clearly, and that is that the hardship has not been self-created. And I have all kinds of examples of that, but it's not self-created, I think, if the owner of the property, he or she has owned that property. I mean, the easiest one to show there is that they have owned the property for, say it's been in their family for decades. And state DOT came along and expanded the roadway. And they're in because they think the market's changed. They do have an economic hardship now. They can't market this site for what it's zoned, the use it's zoned. Well, I didn't create that. That's clearly not self-created. But then there's the applicant who goes before the Zoning Board of Appeals, and they're really a contract vendee. You know, or they were a contract vendee until they got something from the existing owner. Now they just bought the site, and they know full well what the zoning is. Is that do they meet this? Is that a self-created hardship? I had a Zoning Board of Appeals go through the seeker process. They declared themselves lead agency, and in this case, they had a right to be lead agency. And the chair decided, gee, you know, I think they should do an EIS. This is a positive declaration. And we spent a year on the EIS, and it was done. So the EIS was able to answer the question of number 3, we're not going to alter the character of the neighborhood negatively. The EIS answered those questions. The Zoning Board of Appeals turned down the application because they said, how about item 4 hasn't been met? This was self-created, this hardship. I privately said to the town attorney later, and actually to the mayor, I said, listen, we shouldn't, this applicant spent $100,000 on the EIS. If we know it's self-created, or that's going to be the grounds to turn it down, don't go through an EIS. Don't go through the whole, you know, seeker process if it's self-created, because you're really running up costs on the applicant. So a use variance to me is difficult to get, and it was meant to be difficult to get because it questions the underlying validity of the zoning. I'm not saying a use variance should not be granted. You look at these criteria, you look at the site, and you make your determination, you know, and hopefully, I'm sure you all do, in a fair and impartial way. As opposed to item for the area variance. The area variance, the way the legislature in the mid-90s changed this a little, is they see it as, on the area variance, and it's the balancing test. On the side of the card that says area variance, it says the Board of Appeals shall balance benefit to the applicant with detriment to the community. It's a balancing act that you're asked to do. Now then the legislature gives you, the 5 check marks here as items to go through in doing that balancing test. Whether the benefit can achieve by other means feasible to the applicant. Undesirable change to the neighborhood, whether there is one or isn't. And the EAF, by the way, if you do it or if the applicant does it, that environmental assessment form for seeker can help you on that, whether the request is substantial. I get boards looking at this all the time. I just had a board across from a train, this was the Harlem line, across from a train station, 47 units, all, in this case, they were all studio lofts, something the ZBA hadn't been that used to dealing with. And the zoning code of this municipality said that every unit has to have 2 parking spaces. Now, these were studios. Only one person, on average, they're about 5, I know this is going to sound out of context to you, but they're about 500 square feet in size. So they're a little bigger than a hotel room. Hotel room is maybe 300 square feet. The applicant was asking for a parking variance. So we ran through the comparables, the comps we had in our office for this type of transit-oriented, developments right across from a train station. It's going to attract, we think, this in Westchester, we think a younger group of people out of the city, one person, or I call people in transition. They might have got divorced and one of them is going to live in this unit. There's only 500 square feet in this unit. So they're not going to have more than 1 car, really, per unit. There were 47 units. So the ZBA chair said, well, wait a minute, 47 units. That's whatever it is, 90 some odd spaces. We said, they need nowhere near that. They don't need that number. So there was an argument over, were we giving them a substantial reduction? So in that case, we provided all the comps, and we provided from other developments, and we provided data from a national organization on parking and said, yes, this is a big change off the zoning code, but in this particular case, because these are all studios, this is not substantial. And in that case, the ZBA, they mulled it over for several sessions. They didn't give the applicant exactly what they wanted. The applicant wanted a ratio of just 1 per unit. The ZBA gave them 1.25 spaces per unit, whereas the requirement was 2. So there's an argument over substantiality there. By the way, we normally use to figure out space for parking space when we're doing site planning, we usually use either 350 square feet per parking space, because that includes a little of the circulation area, or 400. So yeah, these units were only 500 square feet. I mean, so in the context, it was not substantial, and the zoning board granted that variance. We're glad they did, because quite frankly, there's also this idea now that we want to be sustainable. We want to not have too many parking spots either, because then you got a lot of asphalt unless you've greened some of the spaces, that type of thing. But what you just got into, I'd like to add one thing, not on to throw it out to you. Oh, by the way, don't let me go. Oh, we got time. I'd like to add here a little discussion of, under area variance, because this is where I usually find it, of this issue of nonconformity, which I'm sure you all deal with a lot. And we've had a debate in some of our communities, building inspectors, to see what you all think. The basic principle that the courts have espoused on nonconformity, if someone comes in to you, let's say someone comes in to you, I can set up a situation for you. They come in, it's a single family house. they have a say the municipality has a front yard requirement of 100 feet, and they don't meet it. They have 80 feet. They meet all the other requirements, height, coverage, all the other yard requirements, parking. They want to add on to the house. And they want to add on to the back of the house. And they have a backyard that's 70 feet, let's say, and they're going to add 20 feet to the house to do some type of addition. And they don't need any variance for that. But the building inspector has sent them to you because they do not meet the front yard requirement. And they haven't met it, let's say, for a long time. But they want to add on to the back of their house. Number one is a question, should they be sent to you? And number two, should you grant that variance? We have building inspectors who and I'll show my bias here, we tend to agree with them, who say, look, here's the principle. You should be allowed to do it if you are not adding to the degree of nonconformity. And I've had debates on this. In this particular instance I gave you, if we grant that variance, or if the building inspector grants the building permit, nothing is adding to the degree of nonconformity. The front yard, which is nonconforming, doesn't change. He's adding on to or she is adding on to the back of the house. But it's within all the yard requirements. It's within the coverage. It's within everything. We tend to side with those building inspectors that believe that doesn't need a variance. It's pre-existing, but it's a pre-existing nonconformity. Other building inspectors, though, take the view this has to go to the ZBA. It just has to go to the ZBA. I interpret it that way. So then they have to go to the ZBA. On the basic principle of the court cases, if I were the ZBA, I think that's the easiest one you have to grant, because the area variance is not adding to the degree of nonconformity to anything. You'll see in the Coons write-up here, and you'll find this in Seeker too. In the Part 1 form of Seeker has a question in it. Does this trigger controversy? Okay? Right. Controversy is not supposed to influence you. Now, of course, in reality, human nature, we're all human. If I have 16 people opposed, I'm probably going to be influenced by that. But you're supposed to judge it on these criteria. And they may be right, those 16 people, but it is possible that they're wrong. This leads to conditions, too, and how you do them. You should be careful about due process, the hearing, and writing any conditions, and writing the rationale, which many times your attorney will do for you, but writing the rationale of your decision and being clear that the rationale of the decision is not because 16 neighbors came out, but because 16 neighbors had good points. They had valid points. Does a variance create precedent? And the purest court cases, the purest thinking is a variance is supposed to be granted on the specific requirements of the site, and it's the specific decision before you. And therefore, the courts have said that doesn't create a precedent. However, I just had 3 variances granted in the last year and a half in the village of Tuckahoe in Westchester County. And you bet your life, as a practical matter, the first variance that was granted was the one I just mentioned on parking. So the second guy was already in the approval process with the planning board and realized, wait a minute, the zoning board of appeals just granted a variance because the guy was near the train station. But I'm near the train station. So he immediately went to the ZBA to try to get the same variance. He didn't get the same one because the ZBA felt he was further away and his bedroom mix was different. So the ZBA acted very well in that. But now we have a third developer in, again, near the train station. He knows what happened now in the other 2. So although a variance you grant is not precedent setting, the courts have said, it's supposed to be specific to the site. Nevertheless, everybody else, if they're knowledgeable, they're keying off that. And they're going to say that, hey, you granted it to A, B, and C, why not to us? See, the logic has to be consistent, and in this case, the Zoning Board acted, I think, very well. The degree, the substantive difference that they granted was different for each case, depending on the bedroom distribution and distance from the train station, and they were very good on their conditions. And I want to get to conditions, those conditions need, of course, to be in writing, and there needs to be a rationale to the decision that's espoused. And we have some, I don't know how you all act, we have some of our boards, it's all in writing, so that ahead of time all the board members see it, they edit it, any conditions, or they edit the rationale for the decision, so it's in writing, and then and I don't feel it's necessary to read off something, but most of our boards do. They read it off, even though now we have this debate too. Until a few years ago, we didn't have all of this online. Most of our communities now have a website, so we're putting everything online so the public has it. And when the public walks in, they have a right to the copy of what the ZBA has. Nevertheless, our ZBAs generally still read that decision into the record. There's been a slight change to the Freedom of Information Act. An applicant and a member of the public has a right to anything that you as a board member have been given on that decision before you make it. So they have a right to it. So if you don't have a website, you're supposed to have it available in hard copy. And what we're doing is we post things to the website, but I'll tell you, in some of our communities, the communication is not always between departments, and I don't know. We always bring hard copy. Now, we have hard copy available before your board makes a decision, so that if it wasn't for some reason, the website's down, something didn't work, I don't know, the building inspector didn't get it over to the web person. There's been a slight change to the Freedom of Information laws. And by the way, I wasn't prepared I don't have that with me today. However, your town or village attorney should be giving you this. There's a slight change to the FOIL requirements. And as I understand them now, anything you're going to act upon that night, let's say a proposed resolution, that's got to be available to the public. They have to be able to read it. And now under the FOIL requirements, if I write something for one of our boards and it's not privileged, we do sometimes preliminary drafts, or we do the technical side of it, but it's coming from the attorney. But even in some of our communities now, the attorneys draft. They're making it available just before the meeting in our cases, and just then the public can follow it and read it. So you'll be advised. I'm sure all of you have village or town attorneys. They'll advise you on these FOIL requirements. Let me switch now to something that's totally different, which is the reason I don't like special permits going to ZBAs, but many of them do. And a special permit is a different issue totally from variances. A special permit, sometimes called a conditional use, particularly in other states they call them a conditional use. I liked it better because it's a permitted use. It's a use that's permitted. It doesn't need a variance. It's permitted in the zoning code. But it's called a special permit in this state, and some other states call it a conditional use because it has to meet certain conditions. And you have to apply those to a specific site. So actually, it's not such a good example today, but in many codes, churches are special permits. In every residential area, I find this in a lot of codes. Codes were written this way. We want to allow churches everywhere, or nearly everywhere. And by the way, because of the Religious Land Use Institutionalized Persons Act signed by President Clinton, you'd be wise to allow them almost everywhere. They're considered a protected use under the Constitution and under the laws now, and under the laws of this state, as are schools. So they're usually special permits, but a special permit means they're permitted if they meet certain conditions. And so a special permit, usually you have a general section of your code that has the special permit conditions, and they're usually that part of the code is usually very general and sometimes can be vague. So it's up to you to determine, and it usually has some criteria like neighborhood character or traffic or parking. And if it meets those conditions, it's not discretionary. You must grant it. A special permit, if it meets the conditions, must be granted because it's a permitted use. It's not like a use variance. It's a use that the town board or the village board intended to be allowed in that area that it's listed in the code. But your job as a board, you or the planning board, is to say, okay, though, for this specific site, does this school or this church, does it have enough parking to readily access, are the driveways, are the parking requirements somewhat special to this use? Is it appropriate for this specific location? That's the key to a special permit. And kind of the best write-up I've seen on is by this attorney, John Armentano in Long Island. And there's never been agreement on special permits in this state, and quite frankly in most other states, because it came along as a concept after the 1930s, after these model zoning legislation pamphlets came out from the federal government. And special permits, therefore, the best I can say to it is I heard a Virginia planner explain them at a conference once and say, a special permit that questions the validity of the zoning code should always go to the elected official. And he used as an example a hospital or an airport or something so big that that really should be in the hands of the elected official. And so that, as a special permit, ought to be reserved to the elected official. And then he said, and you may laugh at this, I'm not sure I agree with this. And then he said, special permits that are kind of nuisances, they're problems. He said, those you could send to the ZBA. He said, but all the other special permits that we really want, schools and churches, all of those, he should go to planning board. Because the planning board, those are things you want in your neighborhoods, and they resolve around design issues. They resolve around planning issues, and they're things that you want, and so that they should stay with the planning board. And that was the best description I've heard of special permits and where they go. But in New York State, I think what happened was, I'm not sure of the history because I wasn't around, even though I have a little gray hair. I think in upstate, there was no planning board to send them to. So the elected officials said, oh, hey, we don't want this, send it to the ZBA. So the ZBAs have ended up with special permits historically in zoning codes in New York State. So my plea is to just remember John's article that you all have now. Special permits are different. Forget all you learned about area and use variances. It doesn't apply. Special permits are things that the town board or village board expects you to grant if they meet the conditions. The better word for them in my mind is conditional uses. You do not have jurisdiction to amend in any way the zoning code. Only the elected official can do that. And you only have the powers that are either granted to you by the state legislature, which is only, in your case, the appellate power of variances or interpreting the zoning code, unless the elected official gave you another power, such as the special permit power. So you can't change the code that's written. You can't make policy. That's right. But then there's my favorite topic, and I won't dwell on it, is the State Environmental Quality Review Act. As you all know, you can't take any action. The basic premise, you can't take any action. No one can take any action. The planning board can't. Trustees or town board can't. You can't until you comply with seeker. So if you are the lead aid, then, so the beginning is you get an application and you got to determine are you going to be the lead agency or not. In many cases, the application has also got a site plan. It also involves the planning board. So you have to determine there first whether, as you know, it applies to you at all. Certain variances are type 2 actions. And I forget the 4,000 square foot rule, or I don't have seeker in front of me. You know, variance, I think it's a variance under 4,000 square feet. Do I have that right? Certain variances, they're exempt from seeker. They're type 2 actions. Seeker sets up three types of actions. You know, one is a type 1. It's like adopting a comprehensive plan. It's a development over a certain number of units for your size of municipality. There's lots of things. Adjacent to an historic building, that would be a type 1 action. So there's a lot of type 1 actions. They do a list of them. Then, opposite the type 1 is a type 2 action. Type 2 is exempt. I believe that there's an action that certain actions, like with a single-family house, certain variances under 4,000 square feet, I think it's 10,000 for a school, they're exempt. They're type 2 actions. You don't have to do a seeker for them. Then most actions that are before our boards are called unlisted actions. They're neither type 1 nor type 2. They fall in between. And the unlisted action particularly, that one you don't have to coordinate review. You could deal with the seeker issue before you independently of the planning board. If it's an unlisted action, you don't have to coordinate review. If it's a type 1 action, you have to consider who else is involved. It has to be coordinated. So first the application comes before you. You've got to see, does seeker apply? If it applies, do I have to do coordinated review? If you do, then you got to coordinate usually with the planning board. If you don't, you have seeker before you. You have the application before you, and that applicant has to do an environmental assessment form for you, the EAF, which used to be currently is a, I don't know, 12-page document or something. And you might want to know this, that it's been delayed now till next April, I think. But next April 1, you're going to have it looks to me like a 40-something page document. They doubled the size of the form at DEC. And so next April, the form that you're going to be given for an environmental assessment form is an updated form. It's revised. And DEC's hope is that it will be a better form, leading to more, as two of their attorneys said to me, leading to more negative declarations. We'll see. Jury's out. I don't know. You know, they haven't. Forms are published, and they go into effect next year in April. So you get the EAF, and that's supposed to help you determine, is this done? By the way, seeker comes down to me. Seeker comes down to one sentence, the most important sentence I think in the legislative act. Does this action have one or more significant adverse impacts on the environment? That, to me, is the whole seeker law. Does this action have one or more significant adverse impacts on the environment? If your answer to that is no, it doesn't, that's the end of seeker. You can do what's called a negative declaration. Seeker's over. If your answer to that is yes, then the applicant has to go and do a full environmental impact statement, draft EIS, public comment period, final EIS, and then you have to do findings. I hope you don't do that too much. It really has to be significant and adverse, the impacts. Yes, right. I'll give you an example of sometimes what happens. You know, it's I've had boards of trustees and town boards say to me, oh my God, this master plan's a type 1 action. That's an action more likely to require an environmental impact statement. But the more powerful the board, I think, or the more confident they are in themselves, and there's no more confident than I think the village of Bronxville in Westchester County. It's probably got the highest per capita income, one of the highest in America, and the homes go for about $2 to $4 million apiece and so on. And Bronxville said to me, we don't even have to consider this. We would never adopt a comprehensive plan in this village that had a significant environmental impact. They said, We would always adopt a master plan that had beneficial impacts. We would never adopt a plan that had an adverse impact. It took them 10 seconds to decide that they were doing a neg deck on a type 1 action for a comprehensive plan for the whole village. No one, including Westchester County Planning Department, challenged them. And I believe to this day they were right. They were right. The only thing that counts in seeker is that question, the answer to it. Does your action have a significant adverse impact? Or might your action have a significant adverse impact on the environment? If the answer is yes, got to do the full EIS. If the answer is no, end of seeker. Do the neg deck, go on with your decision for the variance or the interpretation. And that's it. You know, I have communities, I hate to say this, I had a community do a full environmental impact on a 3-lot subdivision. That normally shouldn't happen. You know, most area variances shouldn't have a full environmental impact statement. That's kind of, you know, you ought to be able to deal with it with an EAF. But it all comes down to that one question. Your decision on whether it has a significant adverse impact on the environment. And it's your decision that, and by the way, you can't, the other thing I should say here, by the way, I don't want to, don't delegate the decision. There's a court case down in Portchester. Now wait, there's a worse one, Coca-Cola decision in New York City. The council delegated its decision to their legal counsel and New York City Planning Commission. You can't do that. You can't delegate your decision also to a consultant. The village of Portchester delegated their decision on whether something had an adverse impact to their planning consultant, a terrific consultant. I happen to know him very well. He is a terrific guy. I think his advice was sound. But the court said, we don't care whether his advice was sound or not. You delegated your authority to him. And because he said it was this, you just accepted it. I mean, they didn't debate it. They said, well, Pat says this, so this is what we're doing. You can't delegate. You can't delegate. You can't delegate also to your attorney. And I know, by the way, I want to be very careful here. I always listen to the attorneys very carefully because they're your legal counsel, and I think you should listen to them extremely carefully. And most of the time I would, you know, you'll take their advice, but you can't delegate to them either on, let's say, an interpretation. You've got to make it yourself. You're the ones who make it. Even though your attorney may have a, you know, I don't know, some guys may have a, whatever the advanced law degree is. You know, he's got more education or something, he's really knowledgeable in the field. You can rely on his advice or her advice, but you must make the decision. So same thing in seeker. Don't delegate your seeker decision, make it yourself, but listen to the advice, you know, that you get. And obviously most of the time you take the advice, but there may be an instance where you disagree, and you have to be the final arbiter of that. Okay, well, thank you. Thank you very much. Okay.